Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to Moore Law. I'm Dan Moore in for Deb Haas. Today we're talking about medicine in the law. You know, we trust healthcare professionals to take care of us when we're sick or injured, but sometimes things go wrong. When does a medical mistake qualify as a malpractice? Lots of questions arise in this arena. If you have questions, call us this morning, 513-421-4691. And joining us again is my dad, Don Moore. Good to have you back, Dad.
Yeah, again, doesn't sound like you're so awfully happy to have me
Oh,
here.
well, you know, live TV.
Last year, actually, or last week, actually, I was off in a AAJ, the American Association for Justice conference, to talk about medical education, or not just medical, but education regarding various types of legal cases, and get a little CLE on a national basis. It's a good thing, kind of brings some things back home that hopefully will be helpful.
Every lawyer's favorite thing to do, continuing legal education.
Oh yeah, well, and actually we're lucky today. We've got Steve O'Keefe with us. Welcome, Steve.
Thank you, Don. How are you?
I'm doing great. Steve has done both sides of medical malpractice for his entire career. First part of his career, he did defense work representing doctors and hospitals in cases where they'd been sued, and for the last pretty good while, he's been doing nothing but plaintiff's work, representing people who have been injured. He's recognized as a super lawyer, and he's a local boy. He went to Miami University. Now practices in Dayton. Is that right, Steve?
That's right, Don.
Well, good to have you, Steve. I know that working both sides of the fence gives you some nice advantages, doesn't it?
It does. It gives you a unique perspective of what it takes to be successful in these cases. And families who have been injured in the hospital or a nursing home, they've been through a lot, and you want to give them a fair and honest opinion as to whether they have a potential case, because you don't want to take them down a road and then let them go and say you don't have a case. So it's nice to have experience on both sides.
And some people get confused. They think that a medical malpractice case, you can just carry that case on just like you would a car crash case or something, but there's a lot of differences in there.
There are a lot of differences, primarily the time and expense in pursuing the cases. You can't even file a medical malpractice case in Ohio without an affidavit from a doctor who's reviewed the record saying you have a case. And so it's very important to be able to get those reviews early on so you can let your clients know that whether or not they have a potential case.
Actually, that's a great point. A lot of people don't know that if the affidavit business means you've got to get permission from a doctor in order to make a claim against a doctor.
That's right. That is right. You do. And while it's another hoop we have to jump through to bring a case, the truth of the matter is you need a good expert witness to be able to prove your case. And to get that early on in the case gives the client some reassurance that, that we have a case and we need to go forward.
Great.
All right, well, let's go to the phones. Let's answer some questions. Our first call, I believe, is from Don. And Don, I think you're from Middletown. Is that right?
You're talking to me, Don?
Yeah, that's right, Don.
Okay. Is there any time that a PA can deny you access to your primary care physician?
Okay, when you say PA, you're talking about a physician's assistant, right?
Yes, sir.
Okay. Steve, you want to answer that?
Sure. Don, thank you for calling in today. The answer to that is that if you ask to see your physician, you shouldn't be denied access to your physician. Now, there may be circumstances in the practice that you go to that the physician can't get to all their patients that day, but at a minimum, they should at least schedule an appointment in the future for you to see the physician directly.
And doesn't a physician's assistant have to be monitored or overseen by a practicing physician?
They absolutely do. They can't practice independent of a physician, and a physician is supposed to review everything they do. Absolutely.
Well, one of the things I think that's important to point out also is that, frankly, what a doctor does is a lot of it is mechanical in his practice. He makes judgment calls as to how he's going to set it up, when you're going to see a nurse, when you're going to see a PA, etc. You don't like the way your doctor does it. If you can find somebody who does it different or gives you better service, you can go to another doctor. You're not obligated to stay with that same doctor.
That's a good point. All right, let's go to our next call. I think it's Belinda from Falmouth. Belinda, are you there?
Yes, I'm here.
Why don't you go ahead and give us your question?
All righty. Good morning, everybody.
Morning.
I know I know medical questions can be detailed, so I'm going to try to make it quick.
Okay, great.
My mother has been admitted to the hospital with a broken leg. In the meantime, she has suffered a heart attack, heart failure, and a lung collapse. And she had none of these problems when she went in. And the main problem is, I specifically told everybody in there that she should not have anesthesia based on a near-death experience before. Well, she was given anesthesia anyway. And now we're looking at putting her in a nursing home.
Go ahead, Deb.
Do I have a case? What do I do?
Okay, well, first of all, let's talk a little bit about whether you have a case or not and what the standards are. You've got to be able to show that a doctor failed to meet accepted medical standards in the community that would apply to this particular case, the circumstances that arose in that case. And essentially, this is very important, because just because there's a bad result doesn't mean there's a case. Most of the time, there's not a case. Most of the doctors do what they're supposed to do. With respect to the administration of anesthesia, when you advise them not to, they have to use their medical judgment. If they use poor judgment, and as a result of that poor judgment, that is substandard judgment, and as a result of that she suffered harm, then there might be a case, and it would only be for the harm caused by that. So that's very individualistic. The patient doesn't always call the tune, or the patient's representatives, like in your case. If you say no anesthesia and they think we've got to have anesthesia for this procedure, then they may not be doing anything wrong. A bad result does not always mean that there's a case. So you have to find an expert that would say, like for instance in your case, a heart attack, maybe you need a cardiologist that's going to testify that if they wouldn't have done something that they did do, that there wouldn't have been harm. You have to get an expert opinion, and that's sometimes a difficult thing to do.
And that's really what a lot of these cases come down to when you're investigating. You really have to talk to the experts, and we can kind of get an idea one way or the other, but sometimes you don't really know until that expert looks at it.
That's absolutely true. You need to get a hold of the medical records and have them reviewed by a competent doctor.
Yeah. All right, we'll take a break, and we'll be back in just a minute with more of your questions. 421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law. I'm Dan Moore in for Deb Haas. If you have your question about medicine and the law, you have a medical malpractice question, 513-421-4691 is the number. Let's go back to the phones real quick. I think we've got a call from a caller from Cincinnati.
Yes.
Go ahead.
I would like to know, is there a time limitation from the time of the event to the time of the result if I don't feel that the doctor has done right?
And this is Barbara, right?
Yes.
Thanks for your call, Barbara. That's a real common question, and it's one of the most important questions in any claim. Steve, you want to help us out with that?
Yeah, Barbara, what you're referring to is the statute of limitations. That is the time period you have to bring a lawsuit. And for medical malpractice, as a general rule, you have 1 year from when either you were put on notice of the event or from when you last treated with the doctor. Now, there are a lot of exceptions to this rule for minors, for instance, or for people who may be incompetent. So it's important that if you have any question about the time period to bring a case, that you consult with a competent attorney right away. If an individual has passed away, there's a whole series of different rules in Ohio related to wrongful death cases where you have 2 years from the date of death. I know, Don, that you practice in Kentucky. Is it a little different in Kentucky?
Yeah, it is. Of course, we do Ohio and Kentucky, and,
Sure.
and the statute in Kentucky is essentially the same, 1 year for a med mal in the state of Kentucky. However, there's a difference in Ohio. In Ohio, we can get a 180-day extension, which I know Steve's very familiar with. But we hate that. We think that's a bad idea. We don't like to extend it because you can only get it extended against the people you properly serve. So if you miss somebody, you've got this false sense of security, thinking, okay, I've got it covered, and then you find out, oh, but what about another doctor that might have been involved in it, like an anesthesiologist or a radiologist or something, and you didn't give them a 180-day extension letter? You missed it.
Yeah. Well, it's a complicated answer, really. I mean, the bottom line is it's 1 year, more or less. But there's all kinds of little things that go into calculating when that 1 year starts to run, and so that's a tough question sometimes.
And when Steve said a minor, people should know that means anybody that's under 18.
Right. And then the 1 year's out the window then.
That's right. As a minor, they have up till at least a year after their 18th birthday, and there's a whole series of different rules that apply to them.
Yeah. Okay, let's go to Roger. Roger, I understand you got a question this morning. What can we help you with?
Yes. I went into the hospital for a simple hernia repair. Ended up with the bowel flipping twice, staying in the hospital 29 days. They had me on heavy-duty Dilaudid IV every 3 hours. And then on the 29th day, a doctor from the same practice that I had never seen before come in and discharged me. And discharged me with no pain medication, even though I still had staples. And then I went into severe withdrawal for about 12 days because they had me on Dilaudid around the clock and sent me home on no medication. And even when I went to my family doctor, I had no support there because he was involved with the same practice.
Okay, well, Dad, what do you think about that?
Well, Roger, it boils down to, as we said a few minutes ago, standard of care and frankly, and also harm received, that is damages. So first of all, when they release you, if they've got you on a medication, what they really should do is wean you from the medication. They failed to do that based on what you've told us. If that's the case and that's substandard, then what they did is wrong. Then the next issue is, okay, well, what are your damages? If you're miserable for a week or for 2 weeks or something in that order, that's probably not enough damages that's going to make a lawyer want to handle your case. Medical malpractice cases cost a lot of money. Typically in our office, I'm sure in Steve's office, and in most lawyers' offices who do a lot of med mal, if you don't have a case that's worth several $100,000 minimum, then you can't afford to pursue it. Now what you might do is contact the hospital and see if you can get any help there, because they're the ones that allow the doctors to practice in our hospital, and if they're dumping people out of the hospital without an adequate weaning from the medication or prematurely, then that could reflect on them there, and you may be able to help somebody else down the road.
Well, you talk about expenses in that answer a little bit, and I think this is probably a good time to answer one of those very common questions that everybody always has, and that's how does a lawyer get paid in a medical malpractice case? Steve, you want to address that for just a minute?
Sure. As a general rule, most attorneys who practice in the area of medical malpractice work on a contingency fee basis. That means they charge a percentage of the ultimate recovery. And I know that most attorneys don't charge a fee unless they get your recovery. In a medical malpractice case, the fee is a little higher than in a personal injury case. Most attorneys charge approximately 40%. And the reason for that is that the cases are extremely difficult. There's a lot of risk for the attorney, and that the case expenses are so tremendous. I mean, generally over $100,000 is very typical, and so that's a fairly standard fee. Most clients who've been injured aren't able to work. They've already suffered a tremendous financial hardship, so the attorney is the one who advances those expenses. So that's why the fee is a little bit higher.
So Steve, in a medical malpractice case, if a person thinks they might have a case and they want to contact a lawyer, what's it going to cost them just to contact the lawyer in the first place?
It's always free. You know, the initial consultation is always free, and of course you want to deal with your attorney directly and find out from them their fee structure, but as a general rule, it's free, and it's a good idea. You'll get your questions answered. You know, unfortunately, a lot of times people, when something bad has happened, they get abandoned. No one answers their questions. It's not like an auto case where the sheriff shows up to investigate the crash. The medical board doesn't investigate. If you want to get answers, as a typical rule, you have to get an attorney involved to get those questions answered.
Good information. We're going to take a break, and we'll be back in just a few minutes. We'll see you in a minute. Welcome back to More Law. This morning we're going to give you the contact information for the people who are on the show. We have Stephen O'Keefe, 6239 Wilmington Pike, Dayton, Ohio. His phone number is 937-643-0600. Of course, you can go to gomedmalohio.com for more information about him. And then you've got Don Moore and Dan Moore at 1060 Nimitz View Drive, Suite 200 at Cincinnati, 232-2000. Go to fox19.com for more information on any of our guests. We're going to continue this morning with medicine and the law. We're going to go right back to the phones, and we're going to go, actually, you know what? We're not going to go right back to the phones. We're going to go to a graphic that, Dad, you wanted to talk about when it comes to obstetrics.
Yeah, I did, and we'll get to the phones quickly because we sure don't want to leave anybody hanging. One of the things that I think is really important, and we get a lot of calls about, are when a baby, in baby delivery, what a doctor duty is, and basically what's the doctor supposed to do. And first, they're supposed to seek reassurance continuously. That's why they're there. You know, we've been having babies a lot longer than we've had baby doctors. And what the doctor does is he constantly monitors. He's going to check the fetal monitor strip or check what other people have gotten for him on that. He or she is going to check other vital signs, blood work, et cetera, to make sure things are going well through the delivery. If there's a bad sign, let's say blood pressure is up a little too high, the fetus is not responding to the contractions as they should, then the doctor's job is to determine, do more reassuring things to find out basically, is this just a little blip or is it something to be concerned about? If they find something that's non-reassuring, they investigate, it requires action, then their job is to intervene as is necessary. It may mean induced labor, it may mean a cesarean. If the uterus has become a hostile environment for the fetus, it's the doctor's job to get the fetus out as quick as they possibly can. It's individual, highly individual to the circumstances. All the doctor has to do is what's reasonable under those circumstances. So as Steve said a few minutes ago, getting the medical records promptly is a big deal because you're going to have an obstetrician and probably a neonatologist, which is a doctor that specializes in the condition of babies around the time of birth, review the case and see what problems there were at the time, whether the doctor performed the duty the way they were supposed to do it. Tricky, tricky stuff.
And time is of the essence in these baby cases.
Absolutely. Time is of the essence.
Of the essence for the baby and of the essence for the lawyer.
Yeah. Okay, Ed, we're going to go to you. Sorry to keep you on the phone so long. Why don't you go ahead with your question?
Hi, good morning, gentlemen.
Morning.
Hey, Ed.
Morning.
My question was, my mom, I took her to a doctor on a Friday morning. He was concerned her blood count was low. She had been passing blood and looked a bit anemic. On Saturday morning, the following day, her blood count was 7.6. So they issued a unit of blood. On Sunday morning, I went up there a couple times a day to check on her and try to see the doctors in the morning when they first come in. On Sunday morning, both of her family doctors were there. They were happy with her blood count. She had her color back, went from 7.6 to 8.1, and they said they were happy with that. On Monday morning, she was supposed to have her upper and lower GI. On Sunday afternoon, I went back, and there was another unit of blood on her, and I questioned why there was another unit of blood. My mother was 93 years old, and from there it went downhill. That afternoon, after the unit of blood, they just said a doctor ordered it. They didn't say our family doctor, because when I spoke with them in the morning, they were
Hey, Ed, let me just interrupt for just a second. Could we want to get right to your question because we got limited time.
My question is, on an old heart like that, she wound up with aspirated pneumonia. They ventilated her, took her to the ICU. She spent 10 days in the ICU, and they kept asking me what I wanted to do. If they wanted to trach the ventilator because going in and out.
Let me interrupt just for a second.
Okay.
The little brief we got, because we're running out of time,
right.
The little brief that we got could they be held accountable if they gave her too much blood? Is that your question?
An old heart, blood's protein. I was wondering if too much protein could have drowned the heart.
Okay. And that, honestly, Ed, that is a question for a cardiologist or perhaps an intensivist, someone who manages cases, or perhaps someone who specializes in geriatrics. That's a specific question to your case. The only way you're going to get the answer to that is get medical records, so with all those specifics you were talking about a moment ago, and get it to a doctor who can give you an honest opinion. And that's something, as we talked about before, you got a year in a medical malpractice case. On a wrongful death case, I understand she ultimately passed, so you got 2 years, and if it's in Ohio, that's something you've got to do right now or you'll run out of time. And I'm very sorry to hear about your mom, but best of luck in investigating it.
Okay, let's get to Lori. Lori, you have a question this morning. What can we help you with?
Yes. I have a mother that was in the hospital that had had a series of strokes, and being a stroke victim, of course, she's prominent to falling. She was placed on a porta potty and left for a long amount of time, and she fell off. Would the hospital be negligent in that case?
Okay, Steve,
Good
we got about 30 seconds. You got to do this one quick.
Very briefly, I'm very sorry about your mom, but the federal government's passed a series of rules called never events, things that shouldn't happen, and one is falls in the hospital. Hospitals, and like you said, with your mom being a stroke patient and being at high risk for falls, there's a whole series of steps that are to take to reduce the likelihood of falls. Not all falls can be prevented, but the vast majority can, and it's one of the leading causes of injuries in hospitals today.
So that's a case that should be investigated.
Absolutely. I think you need to have someone take a look at that for you.
Okay, Steve, thanks for joining us this morning. We're real happy to have you.
Great to have you here, Steve.
Thank you. I appreciate it.
Join us next week where we're talking about Medicine and the Law Part 2. Thanks for being here this week. We'll see you next week at 9:30 Monday.